The next appeal on this afternoon's calendar is Appeal Number 32, matter of Seon versus the New York State Department of Motor Vehicles. Counsel?
Good afternoon, Your Honor. May it please the Court, Linda Fang on behalf of DMV. With the Court's permission, I'd like to reserve 2 minutes for rebuttal.
You may have 2 minutes.
Thank you. Substantial evidence supported DMV's determination here that petitioner's lack of due care caused the bus that he was driving to strike and run over an 88-year-old pedestrian's legs, causing that pedestrian to be taken to the hospital where he died 3 weeks later from those injuries.
Counsel, if I can interrupt, Counsel, great, thank you. Can you please set out what is your position on the interplay between the substantial evidence review and the clear and convincing burden that falls on DMV?
Of course. The relevant standard here is a substantial evidence review, and the question here is whether any rational fact finder sitting in the first instance can find the evidence to have crossed the clear and convincing threshold. I think this is not so dissimilar to the legal sufficiency review that this court conducts all the time of a jury verdict. The question is whether or not, so long as there's any evidence in the record that could rationally support a fact finder's determination in the first instance, the substantial review standard is met, and a court should affirm the agency's determination.
But what's the interplay between that and what's the interplay between that and the initial burden on the clear and convincing evidence?
The interplay is only that the initial evidence probably has to be a little bit higher than the usual preponderance standard, but the substantial review is the same. It's whether or not a rational fact finder could draw the inferences from the underlying evidence.
Yeah, but does that mean that the reviewing court has to find substantial evidence that would support a conclusion that there is clear and convincing evidence?
Right, whether any rational, so the reviewing court could find any rational fact finder sitting in the first instance could have found the evidence to have been clear and convincing.
Thank you.
I'm sorry, counsel, have we ever said that? Is there a case from this court? Because the case I see is McKenzie, which is from 76, I think, which in very similar circumstances, the VTL violation and a similar underlying standard just apply to substantial evidence review.
Right, we haven't seen this standard articulated in a lot of cases. But again, it's not dissimilar to a legal sufficiency.
But it isn't a legal sufficiency argument. It's an Article 78 proceeding, which has a substantial review standard built into it. So I don't really see the analogy of a sufficiency case.
Well, I think the point merely is substantial evidence standard is a low bar. It just asks whether or not any fact finder sitting in the first instance could have found the facts and drawn the inferences. And I think on this record here, we have ample evidence of a VTL 1146C violation. And we have the accident report here from the reporting officer who responded to the scene that an 80-year-old pedestrian was found pinned under a bus. This is a New York City transit bus that had 16 passengers on board. We have petitioner's own testimony here at the administrative hearing that he heard a loud thump near the front door and tire of his bus that he was loud enough that caused him to stop the bus and get out to investigate, where he found Mr. Mendez laying just behind the front tire of his bus. We have the police officer's investigation. Officer Vieira, he determined that the bus had hit the pedestrian and ran over the pedestrian's legs. We have undisputed evidence that the petitioner, Mr. Mendez was taken directly from the scene to the hospital for, quote, severe leg injuries, and he was in the hospital for 24 days before he passed away. And the record evidence showed that the cause of death was the injuries and the complications resulting from having a bus, New York City Transit bus, run over the legs.
Do we need to, excuse me, Counselor, do we need to conclude that there was sufficient evidence that he actually died directly as a result of his injuries? Is that necessary in order for you to prevail here?
No, it's not, Your Honor. We think there is ample evidence that this court's role really is only to determine whether a rational fact finder could find, based on the evidence, that either a death occurred or protracted impairment of health. That's what the ALJ found here. He found a violation of 1146C. That statute encompasses both, the relevant term is serious physical injury, and that term in the statute encompasses both death and a protracted impairment of health. And the appellate division here really erred in artificially limiting its review and essentially disregarding certain pieces of evidence on the premise that somehow they could only affirm if there was a finding of death. But I think on this record, even assuming the majority's
Counsel, I think
here,
I think the issue, though, as I understood the majority, and you'll correct me, or if you have a different view, please say so. I thought the majority's view was that you didn't proceed on the alternative ground, that you only proceeded on causation of death, right? That the result was death. And that's where the evidence fell short.
that is what the majority said, Your Honor, but there's a couple of reasons why that's not correct viewed on this record. First of all, DMV does not proceed on anything. This is DMV's function here is purely as an adjudicatory body. This is an NYPD summons as an initial matter. But I think what's really important to note is that the evidence here is, it's one and the same. It's the evidence that the individual had his legs ran over, he went into the hospital, and that he died 24 days thereafter. So it would be hard and implausible to find that there was a finding of death without finding also a protracted impairment of health on this record, but also the parties, petitioners questioning. I see my time is up. If I could just finish my response.
Please.
I think what's really important to note is that petitioners questioning during the administrative hearing made it clear that he understood they were proceeding on both. He questioned the officer both as to the severity of the injuries and also as to the cause of death. So I think on this record here, there's no basis to limit the finding only to death. But I think the record supports here both, and this court could affirm DMV's determination on both. Thank you. I'll reserve the reserve.
Judge, could I ask a question?
Yes, of course.
Just one question, Counselor. If I have this right, it seems to be the core of your argument is that we have to answer the question about the substantial evidence standard, and the key here is basically rationality. And in my mind, I see it, was it rational for the DMV to find serious physical injury / death by clear and convincing evidence? We're not saying that it would be irrational to find that there was no serious physical injury or there was no death attributed to a serious physical injury, but that it was rational for them to find that in this context. Isn't that the core of it?
That is absolutely correct, Your Honor. That's the core and fundamental nature of substantial evidence review. This court's recognized many times that there could be conflicting evidence on both sides, and rational fact finders sitting in the first instance may come to different conclusions, but that's not the role of substantial evidence review.
Thank you.
Thank you.
Thank you.
Thank you, counsel. Counsel?
Yes, may it please the court. My name is Vanessa Corchia from Armiente, DeBellis, and Roden, and we represent the respondent, Wayne Seon, in this matter. The order of the appellate division should be affirmed on the basis that there was no substantial evidence of either no substantial evidence that there had been clear and convincing evidence that either branch of VTL 1146 was met.
Are you saying that, that it would require medical evidence or a death certificate or something like that?
Absolutely.
You are.
Here, as the majority had pointed out, there was not even a death certificate presented, and despite Police Officer Vieira's investigation, he still could not answer the question as to how the pedestrian's legs were injured. Was it the leg? Was it the foot? Was it both legs? Was it both feet? He had no clue whatsoever, and this was despite his investigation.
I guess my question is, Counselor, is that required? Because generally when we decide questions of fact, or when fact finders decide questions of fact, they're allowed to draw certain inferences. And here, I mean, you've already heard your adversary recite probably more of these than I will, but the fact that you have an 88-year-old man, he's found pinned behind the wheel, he's taken to the hospital after hearing a loud thump, and I think there was some adjective about the noise, some other vocalization that the driver heard, and he's taken immediately to the hospital, and he never leaves the hospital. All of those things put together, just as a matter of common sense and drawing inferences from those facts, why isn't that enough?
Because, Your Honor, as I mentioned, this officer that testified, presumably, since he's the one that investigated, he would be in possession with the information necessary to sustain the violation. He has, if the only evidence given is somebody with no clue as to what the severity of the injuries were and what the exact nature of the injuries were, I don't think it's fair to conclude that there was a causal relationship between the contact with the bus and the death of the pedestrian, which occurred some 3.5 weeks later. I would also like to point out that I believe the affirmance could be sustained on a different basis, which we preserved, is that there was no evidence that the bus operator failed to exercise due care. And the only evidence pointed to the fact that he was careful. Specifically, he was traveling, and as the court had noted, he was traveling less than 1 mile per hour because he was making a right turn. He was driving slowly. He was continuously scanning his mirrors left and right. He was turning onto a very narrow street with parked cars on either side. Significantly, it's his testimony that when he began the turn, he looked and there was no pedestrian in the intersection. There's no dispute to his testimony. So what that means, and I'm sorry.
Officer Vieira disputes that, maybe doesn't. Officer Vieira says he should have, given the configuration of the bus and where he was in the turn and the glass door, if he was using due care, he should have seen this pedestrian. Why isn't, he's an expert, right?
Well, Your Honor, he doesn't exactly say that. He does not exactly say that. The specific, there's a conclusion, but you have to look to see what are the facts. And the facts are, again, the bus operator, and this was uncontested, he testified that the front wheels of the bus had already passed the crosswalk, okay? That's uncontested. So when Police Officer Vieira admits that it was just as likely that the pedestrian walked into the bus That's based on the fact that the bus is already in the intersection. That's uncontested. All of this evidence is uncontested. Police Officer Vieira does not ever actually say this accident was due to driver inattention.
Counselor?
He can't, because it's raining.
Counselor?
Yes.
Yes, it's Judge Fahey. Those factual arguments are significant, more so at the appellate division than here, but isn't the appellate division essentially restrained? Their function is not to decide whether it would have reached the same factual conclusion as the fact finder below. The only function of the appellate division is to see if that was a rational decision, not to say if I had been on the jury, if I had been the fact finder, I would have found it differently. So the question for us is, did they apply the substantial evidence rule correctly? Or did they act as if they were the fact finder in the initial circumstance? Isn't that really what you're, before this court, constrained to argue? You're not really here, you're not really allowed to, it's not really relevant for us as to whether or not there are nuances in the facts that could have gone the other way, because that's a perfectly reasonable argument. For you to be successful, don't you have to show that it was irrational and unreasonable for them to find by clear and convincing evidence that they met the standard of the burden of proof?
I submit that it was irrational. Based on all the objective facts that I listed, there's no objective fact given by Police Officer Vieira either on the issue of the serious physical injury resulting in death or on the grounds of failure to use due care.
But there is one fact you didn't mention, I think, which is uncontested, which is he is in the crosswalk with the light in his favor, with the walk light in his favor. No one contests that. So really the argument I think that was made there was he walked into the side of the bus, or the bus turning struck him, proceeded through the crosswalk, and he wound up behind the front right wheels, I believe. So, I mean, there was that uncontested fact in the record also, right, that he was in a crosswalk with a walk light.
No, the uncontested fact, which came from the police accident report, was that the pedestrian was in the crosswalk. Police Officer Vieira said when he had canvassed the 911 callers, they were not able to confirm whether or not the pedestrian had a walk signal in his favor. On the other hand, he admitted that the 911 callers verified that that the bus operator had the green light. I do want to mention on another topic.
Counsel, before you do that, I just want to confirm that I'm understanding what you see is the standard of review. As I know Judge Fahey has asked you about rationality and irrationality, as he did to opposing counsel. But I thought both counsel's argument was that the standard is whether or not there's substantial evidence to support the determination. So I thought really your argument is that there's not substantial evidence to support any of these determinations. Have I misunderstood you?
Yes.
And that it would not be rational if there's not substantial evidence. It's not a rational determination if there's not substantial evidence. Am I misunderstanding you?
Actually, I don't think I put it that way in the brief. My position is you have to still look at the record as a whole. Specifically, my position as there's a case I had cited in my brief, Reap v. Aducci, where the court says substantial evidence consists of proof within the whole record of such quality and quantity as to generate conviction in and persuade a fair and detached fact finder that from that proof as a premise, a conclusion or ultimate fact may be extracted reasonably probatively and logically. So I think when you look at the record as a whole, there's zero evidence that Mr. Seon failed to exercise due care, and zero evidence on which you could base a conclusion that such failure resulted in a fatality.
But
Thank
why
you.
can't you, I'm sorry, if I may? Why, I don't think you've responded to the questions, and I think they may have come from Judge Stein about, or that she raised before, about inferences. Why can't there be an inference or inferences that a elderly individual who's struck by a bus, whether he walks into the bus or the bus walks into him or drives into him, who then ends up in the hospital immediately and stays there until his death, why can't you draw the inference that either the death is caused by this accident or that there is the protracted impairment of health given the amount of time that's spent in the hospital before he succumbs to the injuries?
Because in this case, there's a fine line between an inference and guesswork. I submit that the fact that the pedestrian was elderly for all we know, he died from a heart attack. I mean, we don't know. That's why it becomes a guesswork. The same factor that the dissent had used to say, oh, come on, of course he died because of the bus. I submit that factor that the pedestrian was elderly renders it pure guesswork that there was any connection between contact with the bus and the fact that the pedestrian died some 3 weeks later.
Thank you, Ms. Korcha. Counsel?
Thank you, Your Honor. Just 3 brief points. Just briefly on the due care point, I think there is substantial evidence to support the DMV's determination on that point. And I think we have 5 justices of the appellate division all agree that there was substantial evidence for the lack of due care here. The second point here is there was evidence in the record from which a reasonable fact finder could draw the probable inferences that the death here that Mr. Mendez suffered was caused from the injuries. We have the circumstances of the injuries, which were pretty substantial. He was rushed to the hospital with severe leg injuries. There's nothing contradictory in the record about that. And the officer testified that after his investigation, he had determined that the death was the result of injuries. There's a reference to a doctor at St. Barnabas Hospital who is in the record in terms of the accident report. That supports the causal connection here. And the final point is the one that Judge Stein just referred to, which is common sense does play a huge role in substantial evidence review here. This court's recognized that time and again. And the common sense here is if an individual pedestrian who had the right of way in a crosswalk, and this is New York City, so if the bus had a green, the pedestrian also had the right of way and he was legally in the crosswalk. If he walks into the side of a bus with the bus going less than 1 mile per hour, he does not end up behind the wheel of the bus or make a loud bump. And so here we have protracted impairment of health just from the fact of the nature of the injuries alone, plus the fact that 24 days is a substantial amount of time for anyone to be in the hospital, let alone an 80-year-old pedestrian who, again, was
Counsel,
in the hospital.
let me ask you, if he had been released from the hospital, would you have to have put in evidence regarding his condition at the hospital and upon his release? Let's say he didn't pass away at the hospital. Say he goes home and he passes away within 2 hours. What's your burden? I want to know what you think is your burden. What kind of evidence, would have had to have been presented to support the outcome here, the determination against Mr. Seon?
If the hypothetical had been that he left the hospital in a week?
Sure, a week, sure, fine. I didn't give you a number of days, but that's fine.
I'm sorry. So there has to be some connection there has to be substantial evidence that a reasonable fact finder can conclude that there was protracted impairment of health. And I think in your example is the individual left the hospital, was discharged, and then died a day after. Then in that incident, in that instance, I think there would have been more medical testimony presented to causally connect the two things. And here we don't have that problem because there was a continuous stretch of hospitalization. It's not that this individual
What
left
if
and was
at the hospital,
discharged and then
since,
died
if I can
thereafter.
interrupt
And
you, let me
substantial
interrupt you
evidence
here. What if at the hospital, someone committed terrible malpractice, gave him the wrong drug, and that's what's killed him?
Right, and I think that would be a different circumstance. It depends on whether there is a sufficiently independent event that breaks the causation. In terms of general causation.
Well, all I'm Counsel, if I can interrupt you, all I'm suggesting is that the way the evidence is set up in this record, it demands of the fact finder to come to what I don't disagree with you is, of course, an obvious view of the evidence, that someone this elderly who's hit by a bus, who is severely injured or who's injured in the leg, ends up in the hospital, is there for some period of time, and then passes away, that seems to naturally flow as a consequence of the accident. But what seems missing there is that someone like this at a hospital may be very vulnerable to other reasons for having passed away, or other possible injuries that may occur at the hospital. And it strikes me that that's what the majority is pointing out, that they're concerned about that, the record as presented.
I understand, Your Honor, that is maybe part of the concern that drove the majority in the appellate division here. But again, I think whether there were other causes or not, that would just be pure speculation on this record.
What if the pedestrian was 55 years old?
I don't think the age matters as much, Your Honor, in this record as the nature of the injuries. I think the dissent correctly pointed this out, is any person, whether you're 18 years old or 88 years old, if you have your legs run over by a New York City Transit bus, reasonable inferences could be drawn from what happens to you thereafter at the hospital. And thank you very much.
Thank you, counsel.
All please rise. Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals, held in and for the state of New York, may depart hence and appear here the next scheduled session of this court, to which time this court now stands adjourned unless sooner convened by the Chief Judge or Senior Associate Judge, President of the State.